I am very happy to introduce the first session of the webinar, Struggles for Recognition, Pluralism of Minorities. This session will be on immigration and minorities. This session will be recorded for future uses. And it's my pleasure to introduce you Javier DoradoPorras, that is the Deputy Director of the Human Rights Institute Barolome de las Casas of the Carlos III University of Madrid, Spain. He's going to address us a welcoming speech, and he's going to inaugurate this webinar.
Okay, hi everyone. I hope I can. Sorry, it's open. Oscar.
Yeah, it's open. It's open.
It's open. Okay, yeah. Thank you. Thank you, Oscar. Well, I was saying hi everyone, and I hope to be heard. But I can be heard and seen properly, because I'm having some problems with my connection also. So I hope you can really at least hear me. Okay. Well, first of all, I would like to apologize, as I won't be able to remain with you on the session of the webinar. The reason is that apart from being the Deputy Director of the Institute of Human Rights, I'm also the director of the Master in Advanced Studies in Human Rights, and I'm doing a small break now in the interviews to the candidates for the admission, just to welcome you and to open formally the webinar. Okay, so I hope you can. I ask your pardon. Okay, I pray your pardon. Of course, I'd like also to thank Oscar Perez and Monique Falcao from Universidad de Santa Úrsula for their great work in the organization of this international webinar, Struggles for Recognition, Cultural Pluralism and Rights of Minorities. Well, this webinar is very important for the Institute of Human Rights, not only because it is an extension of one of the most important workshops driven in the Institute, the workshop on cultural pluralism and minorities, managed by Oscar Perez and also by Daniel Oliva, but also because it is a very important opportunity to have international participation from academics all around the world, also for our students and for all the people of our university. So I'm really grateful. I'm really grateful that you can enjoy and have a good time on this seminar. Okay, and also to have a good time to create networks with people from all over the world for future projects. That's what I hope. Okay. For this reason, I hope you will continue on the next years with the webinar, Oscar. That is a very good idea, and I hope that it will be very, very fruitful. Okay. On today's session, it will be discussed the topic of minorities and immigration with the interventions of Aida NAFSTAD, University of Lund, Marc VALLÉS, Universitat de Girona, Conta Al-Hajjade Ali Garba de la Haute École de Travail Social de Ginebra, Augusto VELOSO de la Pontificia Universidad Católica de Minas Gerais, and Stefania ATTOLINI de la Universidad di Salento. Of course, I want to thank you all for your participation and to encourage you to widen the collaboration with our institution. That is very important for us. Okay, and finally, I would like just to thank Ana Juez, the secretary of the institute, and also Lara Cuenca, who is our journalist and social media manager, who have also helped in the organization of the event. And that's all. I don't to steal time to that is academic discussion. So welcome everybody, and I hope you have a very fruitful session. So thank you very much.
Okay, thank you very much, Javier Dorado, for your words, and we really appreciate the support of the Human Rights Institute Barolome de las Casas, that is one of the organizers of this international webinar, and I hope this will be an ongoing activity and will be future events on this topic.
I hope so. Thank you, Oscar. Bye-bye.
Okay, bye. Okay,
bye, everyone.
Okay, then. The session of today will be about the first paper is presented by Marc VALLÉS from the University of Girona and Aida NAFSTAD from the University of Lund. The title of the paper will be Roma Community Victims of Epistemic Injustice in the Legal Field. The second paper will be Augusto VELOSO LEAO, The Struggle for Recognition, the Political Mobilization of Immigrants in Brazil. The third paper will be from Conta Aligarba et Merien, Des idées du nationalisme et du pacte mondial sur les migrations. And the fourth paper will be from Stefania ATTOLINI, University of Salento, Children's and Digital Rights, Effectiveness, Considerations of the Right to Internet. Okay, the structure of the session will be first, all the participants will give their speech. Second, there is a turn for the discussion. In this case, I am the chair of the discussion of the session. I will address questions to the participants. And third, the participants will answer the questions of the discussion. And fourth will be an open turn to address questions to the participant that any person present here in the webinar session could address a question for the participants. And finally, there is a turn of the participants to answer all the questions that has been addressed to them. Okay, this is the order. This is the structure of the session. I am very sorry because Monique Falcao has problems with the computer. I also have bad connection, but I will improve my connection for future webinars. You can, I think you can hear me. Okay, then we are going to proceed, and the first paper will be addressed by Marc from University of Girona and NAFSTAD from University of Lund, and the title is The Roma Community Victims of Epistemic Injustice in the Legal Field. It's your turn.
Thank you. Can you all see our presentation or PowerPoint?
Yeah, I can see your presentation. I think everyone can see. Please, if you have any comment to the presentation or use the chat. Use the chat. You can write something in the chat. Okay, I think the people can see the presentation.
Good.
It's your turn when you...
Yeah. Marc, are you here? I think Marc will start out.
Okay. Yes, just a moment. I am going to give sound to Marc.
Yeah.
Hi, can you hear me?
Yes.
Yeah.
But okay, perfect. We are so happy to be here. I'm very grateful to organizers. We did little change the title. We wrote the persistent oppression of Roma in the legal field, from outlaws to epistemic violence. But it's only a little change. So first of all, I would like to comment that the paper that I have presented together is an intent to open a new field of research, because there are institutional spaces where covert forms of oppression or discrimination are reproduced and need to be unmasked. So we didn't want to be pretentious. In other words, we have not proposed methodological tools to detect the problem or solutions to reverse the problem. So these are all questions we leave open for possible future research. Eden and I share an interest on Roma community and discrimination and identity issues. So in this case, we have revived a philosophical concept proposed by Miranda Frickers. This concept is called epistemic violence. Epistemic violence, according to Fricker, can be defined as the phenomenon of experiencing as a subject of knowledge the disadvantage of being in a relationship of subordination due to identity prejudices. Specifically, we have taken into account what Miranda Frickers called epistemic testimonial violence. What is epistemic testimonial violence? This violence occurs when the prejudices leads a listener to give words of a speaker a diminished degree of credibility because the speaker belongs to a group with a negative identity or a stigmatized identity. Christy Dodson, another relevant researcher, has identified two types of epistemic testimonial violence. First one is called testimonial quitting. What is it? Testimonial quitting occurs when the audience doesn't identify the speaker as a subject of knowledge. For example, when a group of men doesn't take seriously the words of a Roma woman, a gypsy woman, because they believe that all Roma women are illiterate and ignorant. And the second type, proposed by Dodson, is called testimonial smothering. This one is the type which we have worked on to analyze two cases of epistemic testimonial violence suffered by Roma in Scandinavia, but Ida will explain here. So, epistemic violence is linked to the identity phenomenon, specifically to stigmatized identities. In this part of the paper, we illustrate how white European society has historically constructed a negative identity towards Roma, about Roma. Firstly, where Roma arrival in Europe, white European society classified them as gypsies because they believe that Roma came from Egypt, but it's not true. Roma came from India. Moreover, since their arrival in Europe in the 15th century, Roma represented an opposition to medieval and modern European values because they were nomadic. We can find since 15th century different laws against Roma, laws of expulsion, persecution, and assimilation. In these laws, Roma are described as vagabonds, lazy, thieves, pagans, among others. In 19th century, we can find racial and criminological theories. These theories has served to classify Roma as criminals and as racially inferior. Nowadays, according to European Union, the Roma are the most discriminated against minority at all levels. Why? We think that the reason is because the social category gypsies has been historically fed with negative attributes. Let me remember that the social categories also are cognitive schemes, and the cognitive schemes allow us to organize and to understand the social world and to guide the relations in daily life. So, the Roma categorized as gypsies are potential victims of epistemic violence, even in institutionalized spaces. There are studies, for example, one carried out by Barani team, that show how police and judges act motivated by prejudices against Roma. So I now give way to my to Ida NAFSTAD, who identifies two cases of epistemic testimonial violence in Scandinavia.
Thank you very much, Marc. Before I will go on with our two examples, I will have to provide some words about Roma in Scandinavia and the legal framework that has been opposed to them. They have gone the last 100 years from entry bans to a national minority status for Roma in Scandinavia. There have all up till about the mid-20th century, there have been discriminatory laws against the Roma in Norway and Sweden. There has been entry ban for entry into the countries. There have been a banishment from the countries also for Roma with a citizenship status. There have been a ban of traditional Roma profession, forced sterilization, work camps for assimilation, and also forced removal of children from their parents, among many other laws. But in the 70s, we could see a change in perspectives on Roma. Gradually, they went from assimilation to integration, and finally, they gained a national minority status in Norway in 1999 and in Sweden in 2000. And this national minority status entails that the Swedish and Norwegian state has a responsibility to protect and to provide opportunities for the development of Roma culture, identity, and language. So, but what we have seen is that still institutional discrimination did not stop with this national minority status. And we are going to provide two examples of how this institutional discrimination is still taking place. One example is through court in Sweden, and the other is the child welfare system in Norway. And we will try to explain how this is taking place through the lenses of epistemic violence, as Marc talked about. Well, if we first go to epistemic violence in the Swedish court, Dotson, she says that testimonial smothering is taking place when the audience, and in this case it's the judges, is unwilling or unable to understand or acknowledge the testimony of the speaker, which in this case is Roma participants in court, as comprehensible and intelligible as a knower due to pernicious ignorance or testimonial incompetence. So when we have looked into earlier studies from Swedish courts, we can see how the judges in these courts fail to believe or take seriously statements given from a Roma epistemic starting point. One such study showed that such statements are either totally ignored in court, particularly when they are used to justify events, or otherwise we can see that these statements are taken into account only when culture is depicted as something negative, something that has negatively affected the case. In another study, we can see how such statements from Roma victims leads to a denial of victimhood. They are not understood as trustworthy nor credible, unless they can give a statement that depict them as one of us instead of the other, or instead of being a Roma. So this creates a very limited space for Roma experiences in courts. So testimonies must be smothered in order to bear any significance and to be believed in court. And of course, this creates severe limitation in regard to being understood and to deliver a sincere testimony in court. Let's see. Our second example is from the Norwegian child welfare system. In 2015, the Council of Europe's Human Rights Commissioner, he found that about half of the total number of non-immigrant Roma children in Norway are in foster care, or they are vulnerable to this measure. They are deprived of education and practice of culture and language when this happens to them, and they are not placed in Roma foster care homes. So this leads to a high risk of their losing their language and also cultural identity. An earlier Norwegian study has found how the child welfare service officers, they shows ignorance and little knowledge about Roma culture. This is showed in how they regard social problems among Roma as caused by culture and caused by their way of living. Furthermore, they have very limited knowledge and understanding of what culture in itself is. They regard culture as material artifacts, such as clothes, music, and food receipts, and they do not show any knowledge about Roma language or the importance of Roma language in a Roma culture. They do not recognize this Roma speaker as comprehensible and intelligible, but show pernicious ignorance, as is showed in this quote from the same study. This is a child welfare service officer who is saying that, I think they, the Roma, need a change of attitude among themselves. They must accept the larger community and recognize that some of the norms that are in our society, in the Norwegian society, since we talk about them, are good norms that are important to adhere to. For example, that of being honest. So one can say three things about this quote. First of all, it says that the officer thinks that Roma must accept the larger community, not as the national minority status entail that the largest community should accept Roma. Second of all, they're talking about our society, which, according to this, Roma is not regarded as a part of the Norwegian society. And third, it's underlined that they're not seeing Roma as honest. They're not seeing Roma as trustworthy or credible. They are seen as liars. Okay, time is running fast, and we have come to our conclusion. Marc, will you take that?
Yeah, thank you, Ida. So we can conclude that the Roma, since their arrival in Europe, have become the other through the social category gypsy. Social category gypsy is a social category of identity, but a stigmatized identity with negative attributes, where Roma are represented as vagabonds, lazy criminals, thieves, etc. And this social category has served to justify discriminatory practices against them, including from state. Second, we think that the legal protection and social benefits are tools that help to correct inequalities, but they are not sufficient in themselves. According to European Union, Roma are the most discriminated against minority at all levels. And we think that the root problem is because of the social representation about them. So maybe we need intercultural education. And the last one, we have detected that discrimination based on identity prejudice also take place in institutional spaces, in a hidden or covert forms. But this type of discrimination, like epistemic violence, epistemic testimonial violence, also cause damage to human dignity. And this is finished. Thank you so much.
Thank you.
Okay. Ida, you have to add something?
No, thank you.
Okay, thank you. Thank you. Okay, now it's time, I think, that Monique Falcao could address some words to us, because he's now with us. She's joined us, and maybe he as today is the first session of the webinar. She's one of the co-organizers of the webinar. She is one of the organizers. Monique, could you address some words to the audience?
Hi, everybody. I'm also coordinator of the webinar, and I'm very glad to be here with you. I feel sorry for the late. I had a technical problem here. And a little after, I will also make some questions with Oscar. And yeah, please, everybody's welcome. And we'll have a good time together. Thanks a lot. Thanks, Oscar.
Okay, thank you, Monique. Okay, let me introduce Augusto Veloso LEAO. He's going to talk about the struggle for recognition in the political mobilization of immigrants in Brazil. Augusto, it's your turn.
Hello, good afternoon. I will try to start the presentation now. And in the meantime, I want to thank Oscar and Monique for this, for the organization of this presentation, this seminar, this whole seminar, in fact. And also thank everybody for the all the participants for following the presentation today. Can you see my presentation in the screen right now? You can answer from the chat also.
Yes.
Great. Well, as Oscar said, this presentation is going to be about the research, the struggle for recognition in the political mobilization of migrants in Brazil. I'm currently working at the PUC Minas in Belo Horizonte in Brazil. And this research is financed by a research grant from the research agency here in Brazil. With that said, I hope that Brazil reverts its current cuts in the budgets for research here in the country, and especially social sciences. Well, to begin with, I would like to give you some context about the Brazilian migration population. We have around 1.2 million migrants in Brazil in 2018, which represents around 0.5% of the total population. From that migrant population, we have around 9% of Bolivians and also 9% of Venezuelans, 7% of Haitians, and the other group that I'm going to mention tonight is the Angolans, and they represent around 1% of the migrant population in Brazil. Brazil has been recognized as a historical migration country. So all the migration that happened in the earlier centuries have been incorporated to the Brazilian identity, but it has a hard time to recognize the impact and the contribution of recent migration to its population and to its development. Well, to speak of the three biggest migrant groups that we have today in Brazil are the Bolivians, the Venezuelans, and the Haitians. The Bolivians have come to Brazil since 1970s, but mostly in the 90s and in the 2000s. The Venezuelans have really increased since 2015, and the Haitians since 2010. The migration from Angola has been happening stronger since 1989 because of educational program between the two governments, the governments of the two countries. Well, the law that has been active, the migration law that has been active in Brazil from 1980 until 2017 was built in the last years of the military dictatorship. And also because of this, there was a very strong focus on security, and the protection of the national workforce was one of the dispositives that the law introduced. The law also stated very clear that all political activity by migrants is forbidden. A couple of years later, it was promulgated in 1988. A new constitution has been created for Brazil, and that constitution has given equal rights to many equal rights to different people, regardless of the migratory status. That means that this specific dispositive that prohibited political activity turned unconstitutional, although there was no clear message that removed that from the law from 1980. So it was still a doubt if it was active until 2017 or not. So what we see in Brazil is a very small and a somewhat invisible migrant population, which raised the likelihood that this population was victims to human trafficking, work conditions analogous to slavery, and also urban violence. So what this research was trying to address is the question of how can the political mobilization of migrants happen in a context that lacks legal recognition, that they don't actually have the right to mobilize, to be politically active. Well, we have seen this situation before, for example, in the women's political rights protests in the 18th and 19th centuries, in which women organized in cultural and social groups in order to demand for political rights. We also saw it in the sans-papiers movement in France in the 1990s, in which the undocumented migrants were trying to raise awareness about their situation of invisibility and of lack of access to certain services and rights. So most of this mobilization that we are going to observe between 1980 and 2017 in Brazil is a mobilization for migrants, from Brazilians. And there was almost no organization by migrants that were involved in this political mobilization. So looking at the two cases that I'm going to present tonight more specifically, we can understand some aspects of this, of what it means for the migrants and for their claims to be represented by other organizations. I will talk about two cases of urban violence and the protests that occurred next to it. The first one is a case that happened in 2012 with an Angolan student, Zumira Cardoso, which was victim in a shooting in a bar, which was highly popular amongst the Angolan students here in São Paulo. So the case was identified as a case of urban violence, but also with racism, because of the conflict that emerged between Brazilians and the Angolans that were in the bar at that night. So not only it involved the migrant community and the migrant organization, but it called the attention of the Black Movement organization. So there was a widespread protests and widespread mobilization in order to demand for more visibility to the issues lived by migrants. This protests and this movement was able to access the governmental institutions that worked against racism in Brazil. So that helped them a lot to get the political response they wanted from the government. The other case that I'm going to analyze a little bit further tonight is one of the a Bolivian boy, Brian Captcha, which was a victim of which was killed by during a robbery in his own home in 2013. This case was mostly identified by its urban violence strain, but also the protesters were demanding the punishment of the suspects. They were very preoccupied with that aspect of the protests. So what they organized was a lot of street protests, which in fact were similar to what the Brazilians were doing at the moment. In June 2013, there were a large number of protests in the street in Brazil, especially demanding more, displaying insatisfaction with Dilma Rousseff government at that moment. This group didn't have the experience necessary to access the institutions to demand for their rights. So what we can see in this case is that they weren't as able as the group before to demand political answers to their demands. So what we can see in both cases is a tragedy that creates an awareness of injury, that people recognize that it's not only one person who is suffering with this urban violence, with this racism. It's a widespread situation. So this emerges or creates a disrespect frame that helps the struggle for recognition for a right. In this case, the right for public security and the right of non-discrimination. So what we can see is that there is a big importance of what is the frame that the protests and the political mobilization chooses or has access to mobilize in its protests. In case of racism, it had better luck to access the institutional organizations and have a political response. In the case of the frame of urban violence, it wasn't so successful to demand for political answers. So you can see that these migrants, they were walking a line between the illegality of their mobilization, because it was perceived that political mobilization for migrants was prohibited by the 1980 law. But at the same time, they had specific demands that that wasn't recognized, that wasn't understood, that wasn't identified by the Brazilians, neither the Brazilians who were working with the organizations for migrants. So what we can understand from this situation is that the migrants need institutional avenues, and they also need experience to be able to present their demands to a public and also require a political answer to it. From that, if this doesn't exist, we can identify the persistence of injury and disrespect in the context of legal and social misrecognition. So if you only have mobilization for migrants, you can see that there will be a gap of these specific demands that the Brazilians don't suffer in the same sense. And this can augment a feeling of social injustice for this specific group. And when we observe the whole situation like this, we can argue that the persistence of this legal and social misrecognition is the source of the lack of integration, and not a result as is normally seen, especially by political institutions. Well, the good news is that the mobilization that the migrants did in 2012 and 13, and of course all the mobilizations that came before that, had the outcome to be recognized and to have a municipal response to local migrants. It wasn't yet a widespread and national response, but it also started the discussion on changing the migration law in Brazil, which happened in 2017. So this is in general what I wanted to present tonight. I thank you all for the interest in the research, and I also am ready to answer the questions that you might have.
Okay, thank you very much, Augusto. Very, very interesting. Both presentations has been very interesting. I'm afraid Ali, our friend Ali from Mali, is not here. Are you here, Ali? No, I'm afraid he's not here. Then we are going to give the word, give the speech. Now is the turn of Stefania ATTOLINI, University of Salento. He's going to address a speech, paper called Children and Digital Right Effectiveness, Considerations on the Right to Internet Access. Stefania, is your turn.
Thank you, Professor. Can you hear me?
Yeah, I can hear you. Yeah,
Okay.
we can hear you.
Okay. I'm sorry my camera doesn't work, but so I start, and my presentation today focuses on the right to education for children and the need for internet access, especially after the COVID-19 pandemic. In particular, I want to assess whether in the European Union, the economic and social policies concerning, above all, children and education take sufficiently into account the need for a universal and affordable internet access today. As UNESCO promoted in the internet universality concept, internet should be based on human rights, should be open, accessible to all individuals, and should be nurtured by multi-stakeholder participation. And I also wondered what should we expect to happen in the future, so in the post-pandemic period in this field. I don't have the time for presenting my whole research, therefore I will try to summarize it by highlighting the most important considerations, in my opinion. In particular, I will focus on 3 different points of the protection of children on the internet. So the first relevant topic I want to talk about is digital literacy and the protection of children online. In fact, the protection of children within the European Union in relation to the use of the internet has always been aimed at providing them with all necessary skills and information to protect themselves from the risks they may face online. Namely, the digital literacy is considered as being the culmination of the entire process, that is the media or digital education, so education achieved by using digital tools. In this context, I think we can examine all the initiatives taken at a different level of the decision-making process, aiming at, for example, including media education in the school curricula. There are also other policies at the EU level promoting the diffusion of positive content for children and made by children. So the aim of these policies is the creation of a safer and age-appropriate online environment and the education of children for their complete participation to the democratic society via the internet. We should also underline the impact of the use of internet, of the use of the soft law instruments in this field. In my opinion, this impact emerges when studying the internet context in general, and this is also true in relation to child protection online. I'm referring in particular to all the forms of cooperation and dialogue between the private sector and governments, supported and coordinated by the public sector in order to establish, for example, good and shared practices for the protection of children online. So we can say that the evolution of the protection of children on the internet can be read as being characterized by the retirement of the state in its traditional meaning, becoming a part of an innovative governance process at national or supranational level, in which participation and consensus among stakeholders arise. The use of not binding tools is often justified by their flexible and adaptable nature, which better responds to the challenges of the internet. Some examples are the Declaration of Principles, which proclaim the need for the protection of children, and which also identify the actions operator can take in order to prevent risks, but also in order to put in place effective processes for reviewing or removing offensive content. Another point is the internet access itself. Namely, the internet and the media cannot be just a subject of education anymore. They are above all tools through which children receive their education and can enjoy their rights. I think that, especially today, the right to education gives an important point of view in the discussion on the existence of a separate right to the internet access. Above all, after the important role it did play in guaranteeing the access to education during the pandemic crisis and the physical closures of the education institutions, bearing in mind what article of the International Covenant of Economic, Cultural, Social and Cultural Rights states about the derogation of these rights. So, however, the lockdown experience proved that the right to education is exposed to violations in practice during an emergency situation. As the Organization for Economic Cooperation and Development stated in a recent document of 2020, increased digitalization creates inequalities between children on the basis of their social context. The effect of this education gap may last. If appropriate action is not taken, the legacy of the COVID-19 will be even wider gap. Would be an even wider gap between advantaged and disadvantaged children. In this view, the growth of digitalization and digital services can bring to a deeper digital divide, and therefore to a deeper division in society, and all this cannot be managed exclusively by a soft law approach. It requires indeed the state to take appropriate measures in order to eliminate social inequalities. In fact, general comment of the Committee of Economic, Social and Cultural Rights concerning Article 13 of the United Nations International Covenant provided that states have obligations to respect, protect and fulfill all the essential features of the right to education, which are availability, accessibility, acceptability and adaptability. The improvement of the access to the internet is also important in the recovery process for states. I would like to close my presentation by quoting the conclusions of the Council of European Union of 2020 concerning the education post-COVID-19. In the conclusions, the Council calls on member states and their education institutions to put in place measures intended to reduce the digital divide, namely by supporting the creation of virtual learning environments or by identifying students that are not able to participate in distance learning and reaching out to them by providing the necessary equipment and internet access. So not only the connection, but also the necessary equipment. And also those measures should be addressed in particular to those from geographically isolated and socioeconomically disadvantaged areas and backgrounds, as well as distributing printed education materials when necessary. Other actions the Council suggests to member states in order to reduce the digital divide is by facilitating access to digital content in libraries. In my view, this could be a starting point for an evolution to a better inclusive digital society. Thank you.
Thank you very much, Stefania. Very interesting also. Well, now is my turn. As discussant, I am going to address a question for each of the participants. On the first paper on Roma community and the epistemic justice, I think it's a very interesting concept, is epistemic justice, how stigma functions in justice, how in the criminal system, how stigma functions. I think when you were talking, I realized that some of these ideas has been developed with another terminology by Marian Young in Justice and Politics of Difference and Democracy and Inclusion. And I think she has a theory in which the stigma is something relevant in politics and something relevant in the organization of society. Okay, my first question is how to avoid or fight against epistemic justice. The solution of Young is the dilemma of difference, how to leave the dilemma of difference. And my second question is, can epistemic justice be useful in other domains such as politics or labor relations? How they work, this epistemic justice in other domains different than, well, as we are three, you can, in the conferences, the discussant tell all the things, but maybe it could be more lively if you answer now, and then I make the questions for the second participant. Could you answer now these questions?
Yes. Maybe I should can start out, Marc. Well, thank you very much for your thoughts about our presentation. I have not heard about the reference you're mentioning, so I will be very interested if you can send it to me. I don't think I got the proper name. But I was thinking I would try to answer your first question on how to avoid or how we should approach epistemic injustice. And I think that a key word here might be recognition. And that is recognition, recognizing the other as equal while also accepting differences. But as we underlined in our paper, a formal recognition might prove not to be enough, actually. We have seen that in countries like Romania, or as we presented, Sweden and Norway, where Roma are actually legally recognized as national minority. And in Romania, there are also Roma political parties in parliament, but still we can see how exclusion, discrimination and prejudices are at high levels in these countries, even though we have this formal recognition. So we believe the root of the problem more lies in the negative social presentations that are linked to the gypsy category, as Marc presented, and the following prejudices, but also in lack of knowledge, and particularly the lack of knowledge in among people in powerful position. And that is something we showed in our paper. I can mention, for example, that the judges in the study we are referring to, they had very limited knowledge about national minority, if they had any knowledge about it at all, and they didn't have any knowledge about Roma law, and also that the child welfare workers, they had very limited knowledge and understanding about culture, as I presented, and no knowledge about the importance of it. And both judges and the child workers, they imagine culture to being something that belongs to the other, culture being something mostly being an obstacle. Culture is being a cause of social ills or impairments, particularly the other culture. So I think in order to deal with such a pernicious ignorance, which lead to this epistemic violence and epistemic injustice, one have to address these real knowledge gaps. And these real knowledge gaps among particularly powerful people in powerful position. And as Marc mentioned in the conclusion, I think one way is intercultural education of the population in general, but particularly of people in powerful positions. But I think there's no like one silver bullet on how to do this. One need many things, many intervention. Another thing that has shown to be important in these cases is that can contribute to fight epistemic justice is raising awareness, providing dignity and recognition of minorities. That we have one example, recent very good example of this in social movements is what we have seen lately with Black Lives Matter movement. yeah, oh, this became a very long answer. Marc, do you want to say something about the other question?
It seems that not. I think he has no very good connection. Do you want to talk, Marc? Now is the time of the discussion. All the questions will be
Can you hear?
at the end,
Yes,
of
please.
the session.
Yes, please.
Yeah, Mr. Kumar. All the questions will be discussed at the end. At the end.
Yes, I would like to raise some questions, sir. Please.
Something?
Can I speak? Can I speak?
Okay.
You are listening my voice?
Yeah, but are you listening me? I am telling that now is the time of the discussion.
Oh, yes, please. Yes, please. Thank you very much for providing me an opportunity, sir. My question to Ida is, why discrimination, exploitation, and oppression is prevailing? Who governs this system? This is my question. Why?
Could you?
Why the discrimination, exploitation, and oppression is prevailing? Who governs this system? Thank you.
Thank you for the question, and I think we will save it for the part of the session where we are through the moderator's questions, and I have written it down, and we will save it for audience questions. Thank you.
Okay, then now with Augusto. Augusto VELOSO, I have a question for you for your intervention. Very interesting, the situation of immigrants in Brazil. You have done a landscape, a view on the situation of the immigrants in Brazil. Very interesting, the change in 2017. Okay. I want to give some information for in general about the Spanish Constitution has distinguished the fundamental rights that come from human dignity that are for everyone, and the fundamental rights that derive from citizenship only for citizens. On this view, right to assembly and association are the first kind, or of the first kind, and the electoral rights are of the second kind. Okay, for me, it's not quite clear what is the Brazilian system, and if the right to assembly and association is recognized to immigrants and also to illegal immigrants. In Spain, irregular immigrants has right to assembly and right to association. Also in Brazil, that's my first question. The second question is justified the exclusion of immigrants from the right to vote? What about electoral rights? Why a person who is living in a country for 10 years cannot vote in a local election or in a regional election or in a national election? What are the reasons behind? Augusto, if you are so kind, could you answer these questions?
Yes, thank you, Oscar, for the question. Well, I guess this is the biggest issue and the biggest questions that we speak of when we're talking about integration of migrants and also about fundamental rights. I don't have an answer to that because I believe this should be a political answer. That means that the community should sit down together and discuss it and come up with their own answers. My work was in the direction to show that the absence of the possibility to for migrants to participate in the political life, that means voting or other ways of participating in the political life, for example, by public commissions or by having a representative that can get their demands. My argument is that when this system that hears and recognizes the migrants as people, of worthy of participating in the decisions of the community, that hampers that that's a very that's very harmful for the integration of migrants, because they will then get this feeling of social injustice that will separate them from the whole society. And as and for your question about the how is today, the rights today, so the Constitution of Brazil has guaranteed what we call human rights for everyone, and without distinction to migratory status. That means that migrants have access to civil rights and some political rights. For example, the right of assembly and the right of political opinion and the right of press. Those are guaranteed for migrants since 1988, which wasn't very clear until the change of the immigration law in 2017. But it was just a matter of interpretation, I would say. And for the electoral rights, migrants aren't allowed to vote or be voted unless they have unless they naturalize as Brazilians. So this is still a ongoing discussion here in Brazil, and I'm very curious to see, for example, the political mobilization of the Venezuelans who are arriving in the latest years, and also from the Haitians. We can already see there's a very big difference from the mobilization from before the 2017 law. Something like Ida and Marc were talking about the epistemic injustice. So this is starting. Migrants are starting to be able to fight this epistemic realm, although they don't have access to the political realm yet.
Thank you very much. Yeah, very interesting. Later, if the participants want to speak between them and want to ask questions between them, of course, you are allowed, and you can do. This is one of the things of the webinar, that we shared previously the papers, and we can ask questions between the participants and also with the audience. Okay, finally, Stefania Tolini. Okay. My question is very interesting paper also, because it's for a question that now is in current affairs: the right to education and the right of access to internet. My question is a question of legal theory, more or less, or constitutional theory. This right to access for internet for children is a civil right similar to right to information or free speech, or is a social right similar to right to education? Can it be a fundamental right? Because depending on if it's a civil right or a social right, or depending if it's a fundamental right, or it has can have different protection in different countries. How can, or is so new this right, and there is no legislation about this right to access on internet? Could you be so kind, Stefania, for a question?
Yes, thank you for your questions. Concerning the first question about the if it could be considered as a fundamental right, I think that we should focus on the absence of a binding instrument, at least at the European level and international level, proclaiming it. The internet access has been considered as an enabler for the enjoyment of other fundamental rights. So the problem is that there is not a common and shared definition of what the content of the right should be. So a good answer to these questions maybe depend on how we interpret the content of such rights. The question is, can we conclude for the existence of fundamental rights, even if there is no provisions which proclaim this? Maybe we could, if we could consider the dynamic nature of the law and the fact that the existence of a right is necessarily influenced by instances coming from society. In this perspective, legalism of a right, of a law, depends on the effectiveness principle, in my opinion. So the right to have the availability of a broadband connection at an affordable price could be interpreted maybe as a social right, as a right to participate in the democratic society. In 2020, today, we still don't have a real discussion, a real political discussion on the right to access to the internet, other than the academic and social discussion. We discuss a lot about other important issues like an open and safe internet and services. All these discussions are really important, but it is pretty nothing to people who are not connected at all. So in this context, maybe the role of the European Union may be very important because it can be it represents the idea of suprastructure environment where the discussion and negotiation of the internet governance issues like the internet access should be promoted. At EU level, we have a provision of universal service, which require member states to ensure that all consumers have access to an affordable price to internet, at an affordable price to internet access at a fixed location. So it still regulates services, even if it recognizes that a risk of social exclusion arises from the lack of such access. Maybe the development of online public services and democratic and participation tools could facilitate the recognition of the right to be connected. So at least we can consider it as being an essential service, This idea could bring to the recognition of its fundamental role in an economic-oriented society. Concerning the second question, so if the right can be considered as a civil right or a social right, I think that something we can easily find discussing and researching about the access to the internet is its aim of creating inclusion. Like, for example, in the UN Convention of the Rights of Persons with Disabilities at Article 9, where it promotes the access to new technologies, including the internet, as a tool for inclusion. Also, the issues concerning the need for bridging the digital divide are related to risks for exclusion. The recital, if I remember well, the 2212 of the directive of the European Electronic Communication Code says that the universal service is a tool for avoiding the risk of social exclusion that arises from the lack of such access for the citizens. So in this perspective, we can underline the difference between the meaning of inclusion and the meaning of integration. So it's not the citizen who must adapt, but it's the society. In my opinion, so in this perspective, internet access can be a social right, but not for its nature, but for its functions. I don't know if I answer your question.
Very interesting. Yeah, it's a good point. I think Marc is going to answer the question because now previously he had bad connection and now he wants to answer.
Yes, thank you, Oscar. I lost my connection. Regarding the second question, epistemic injustice can take place in any space of daily life, in politics, labor, or family, domestic relations, because the power relations are everywhere. Identity prejudices are not only based on ethnicity, also on gender, class, age, among others. So we can imagine a hypothetical case where during work meeting, the boss doesn't take seriously the opinion of a woman worker because he believed that all women are more intuitive than rational. So this belief, this prejudice, is based on a social representation about gender. But in any case, doing epistemic justice consists of recognizing subject with the capacity to produce knowledge. For example, the scientific field is a field colonized by Western scientific knowledge. So recognizing the knowledge of indigenous medicine is an act of epistemic justice. I think, in my opinion, that the education based on social and cultural diversity is the basis for epistemic justice. Intercultural education is very important to break down the preconceived ideas that we use consciously or unconsciously during our relation in daily life. So intercultural education must recognize the subordinate groups are not only passive subjects of history, but also as active subjects of history. This is subjects that produce knowledge. This is all. Thank you.
Okay, thank you. Thank you. Well, now is the turn of the audience, or if any participant want to add something and want to talk. Okay, if you can raise your hands and yes, Monique, you want to add something?
Yes. So hi. Very happy to hear all of you. And actually, I was thinking here there's something maybe in common that I could see in our works. I will say just kind of a provocation, yeah, just to put on table to discuss a little. Just like this, Marc just said now about this epistemic justice. It reminds me a lot some what we have in Brazil, and I also asked now. I'm trying to make a dialogue also with Augusto about the what we call new social movements. It means we have a theoretical in Brazil. She's called Maria Gon. She works a lot with Touraine. It's a French author, sociologist, and they try to understand the individual or the subject of right as a social actor, just like Marc told now, to be recognized by his culture, by his specificities in the daily life, for instance, yeah. And this is quite interesting because in Brazil we had these new social movements. They grow up since 30 years, for instance, and they are responsible for a lot of very new rights that we have in the Brazilian constitutional. Some, for instance, we had a kind of a decolonized epistemology or something like this, decolonizing epistemology. And people can think that is decolonizing or decolonizing building of knowledge. It's only for these ex-colonies, but no. It's a kind of, it's just to think that this way of thinking about the European knowledge made from the 80s, Illuminism, rationalism, and all these things, this kind of universal knowledge or universalism that we have needs good in some way, of course, but actually this decolonizing can allow us to think and also can help us to understand the right to recognition for minorities. I guess maybe in, I would not say in all of ways, but in most part of them. And I guess that they can dialogue a little with what Marc said and Augusto sometime, for instance, and also what Stefania also said. And maybe because yeah, just because of this kind of this recognizing for culture, I was very impressed from Marc and Ida about the Roma. Really, I would not imagine that this would be so. I would say this epistemic or this epistemic justice and also injustice. Yeah, because in Brazil we say like it's a kind of we say. This is structural discrimination, for instance, for the descendants of ex-slaves, for instance, in the court justice and in all kind of institutions we have. So I don't know. It was to make a kind of provoke, just to promote a kind of more dialogue. And yeah, is this and in the work in Augusto work, for instance, there's something that he said that I could see very interesting. I would say he in the slides he was presenting, he did a note like I wrote here somewhere, organizations for migrants and organizations by migrants. That's very interesting because it can also as I could see, Augusto, please say if this is correct or not. But when it's for, we cannot just make the migrants or the minorities to have a voice. But when we say by, then maybe they have a voice and they can be real political actors and real social actors and real historical actors of their own rights, of what they want, of their demands. As this, and yeah, okay. So that's only a kind of a talk. Okay. Yeah.
Can I answer?
Okay. Yeah.
Is it open for answering? Yeah. Thank you very much for these comments. I think they were very valuable and interesting. This of connecting the decolonizing with the epistemic justice. It takes it to yet another level, I think. And I think you're quite right in how one can think about decolonizing knowledge, decolonizing university. There's a campaign on that note, and also thinking about decolonizing schools. But I think that maybe this tool we are proposing of epistemic injustice can be a tool to help us see these colonizing practices. For example, in Scandinavia, people might say that there are no colonizing practices in Scandinavia. We don't have any experiences of being a colonial state. But with this tool of epistemic injustice, we can see that we also have these practices and we also need to decolonize our knowledges. So thank you.
Good. Thanks a lot.
Okay. Okay, our colleague from India want to say something?
Yes, thank you very
Yes.
much for providing me an opportunity. My humble submission is that why migration is taking place during COVID, the reverse migration is taking place. Why minorities and migrants are not safe and secure. Why the United Nations and other agencies are trying their best to connect the communities through mobilization, which is the need of hour. This is my question to Mr. Professor Marc VALLÉS. Thank you.
Okay.
I don't know. Please understand the question. If why they don't have a safe or and security, or
Could you repeat the question, please?
Yes, yes, please. Today we find that minorities are not safe. Migration is taking place. Due to COVID, reverse migration is taking place from urban areas to rural areas. And now we find that there is a crisis of governance which is taking place in each and every country. This is my humble submission. Whether I will repeat again?
No, it's okay.
My first
Thank
point
you.
is crisis of governance. First point. Second, why migration is taking place. Third, why minorities are not safe. Number four, who governs the system. These are my humble submissions.
I don't know if Marc wants to say something.
I don't know what response. I have a little bad connection, so it's cutting sometimes. I understand that why the minorities don't have safes. I don't know, because I didn't understand good to answer well. Oscar,
Okay. Yeah.
I don't know if you understand.
Yeah. Well,
Mm,
it's difficult to say that minorities are powerless people. Usually, few people could be also numerous people in a society, but in a minorized position. This is what is minorities with right of minorities. Usually, minorities, less people, discriminated people, are people who suffer more situations like the crisis, the COVID situation, and this is the reason why we are doing this webinar, the struggle for recognition, because there are people who are in minorities, who are minorities, who are members of the minorities, and these members of the minorities and these minority defenders needs to be recognized for the majority, needs to be recognized for the majority, and this is the general idea behind this webinar. For example, for me, it's very interesting that the paper of Augusto used the terminology and used Honeck, struggle for recognition. You use this terminology and you use these ideas of Honeck, and it's very useful for your paper. And in certain way, the paper of Marc and Ada is also talking about recognition or a form of disrespect or lack of recognition that is the epistemic injustice. And this is interesting because there's a connection between the paper of Augusto, the paper of Marc and Ida. Okay. There is, please, if you are interested in intervene, raise your hand and ask your questions. Raise your hand, it's your turn. If you want to intervene, if you want to ask something to the participants of this webinar. Okay, Monique. Good. It's your turn.
Yeah. So also nobody raised the hand up, so I come here again.
Yeah.
And I'd like to ask to Augusto if Augusto has some made I could see on the bibliography, the list, the references that he worked with some Brazilian authors that for me they could dialogue a little with this kind of there's a Southwest epistemologies, and so that's why I'd like to ask you if you make this link in your work, I can see it's a work that doesn't dialogue so much with this legal theory and philosophy, epistemologies, and all these things. But I could also see, and in your text, and also in the way you write, just like I told you, I could see very well the difference between organizations for migrants and organizations by migrants. So this difference for me was very interesting, and this is the resume of your work, I would say like this. If I could resume your work, this would be in this one. And so that's why. I could see José Torres, if I not José de Souza, sorry, in your bibliography, and also if you know maybe Maria Gon and this new social movement. What do you think about this bibliography? I would say if you dialogue with them in your research or not. Please, this.
Well, thank you very much, Monique, for both questions. I was waiting to see if there were more questions to intervene before I could answer them. But yes, indeed, there's a lot of common points in the research that I presented tonight and the research from Ida and Marc. I think we are dealing basically with a very similar situation in which a group is a minority. They hold certain rights. They have a lot of difficulties to have their rights guaranteed because of in the case of in the terminology that Marc and Ida chose to use because of the epistemic injustice that they are suffering. And I don't know much about the Roma communities, but I do believe because they have had access to legal rights for a longer time than migrants in Brazil. I believe they must have a lot of organizations that are run by them, and that difference that is already a big difference, as you were noticing, because indeed people only become real political actors and they get experience how to present their issues and how to get answers from them for them if they are engaged somehow in the political scene. So I am in this this. I mean, this is a very short presentation, but I am indeed attracted to these questions that you were asking about the new social movements and the Agon and how they can help us understand the situation about the political mobilization of migrants. So yes, indeed, I have a lot of interest in these issues, and I'm trying to tackle them in that way.
Okay, thanks, Oscar. Yeah, thank you.
Thank you, and maybe a question for Stefania about I would like to know if you have studied or you have analyzed the issue about when you tell about the offensive content for children, okay, I have studied the question of hate speech, and it's very interesting how could be the regulations of hate speech in on the internet. But the point is, you are talking about children, and you have used the term offensive content. Maybe you are talking about pornography, or you are talking about violent content. I would like that you specify a bit more how is determined what is offensive content for children in internet, and what are the problems with this offensive content? Because, for example, the discussion between Dorkin and McKinnon with free speech and pornography is an open debate in the American society, and there are other debates about free speech and hate speech also open in the American society, and also in the European society, how to regulate this in the internet. And how can you classify this offensive content on the internet for children? Do you have some idea about?
Okay, thank you for your question. And okay, maybe the problem is that I don't know what an offensive content is, but the problem for me is that nobody knows. I mean, the problem is that we don't have a standard of what it is. So the problem is that we allow private sector and networks to decide what an offensive content is and to remove it. So the problem is that what I was trying to underline, the problem is that private sector is not could not be prepared for such tasks, because the government, if we want the private sector to remove or to decide to remove a content, an offensive content from the web, from the internet, the government must publish something about the standards or the conditions or requirements for a positive content. So something that is not a positive content maybe can bring to an offensive content, can be an offensive content. So the problem is that is this retirement of states from their staff in this context, from this perspective, in my opinion. So I don't know what can be what the offensive content is, but we have from the private sector a definition of positive content, but we don't have a binding instrument who says what an harmful content or an offensive content is. So this is the problem, in my opinion.
Okay, yeah, well, it is interesting now, because one of the arguments of censorship of pornography and violence is children. One of the good arguments with these matters could be what happens if they affect children, if certain images or certain videos could affect, how they could affect children. But okay, maybe
okay, if I can say something.
Yeah, of course.
Okay. In my opinion,
Stefania, I don't know, but I can't hear you. Stefania? Stefania? Well, I think I have reconnected, and also Stefania. Is there anyone that wants to speak, that wants to say something, wants to ask something to the participants? Maybe we can wait for Stefania if she arrives in a few moments. If not, we are going to close. What do you think, Monique?
Yeah, actually, if we would stay here, I would start to dialogue about, for instance, these things. I would start talking a lot about it. So, but yeah, I don't know. Maybe it's time to go home. I mean, everybody's already home.
Oh, yeah. Okay. No, Stefania.
yes.
Yeah. Tell what you want to tell.
Okay, because I didn't see, I was disconnected. I said
Yeah.
that the problem is that more with the fake news issue than with the hate speech, because at least I think that hate speech corresponds basically to illegal content. In contrast, fake news regarding or concerning children can be harmful, but they are not necessarily illegal. I don't know if I was clear, if I made it clear.
You talk about fake news.
Yes.
Okay, but okay. Okay. Well, okay then. Thank you very much to all participants for being today here. I will tell you that this Saturday, 18th, we have another session at 7 p.m. On nationalism, recognition, and free speech. We are going to talk about also free speech issues. Thank you very much. I think it has been a very fruitful and very interesting session. I like the papers. And thank you, the participants, and thank you, everyone who has attended this session. And I don't know if Monique wants to add something.
Yeah,
or
actually,
everyone wants to add.
We could make another session to discuss, to get deeper on these things we started here, because now I have a lot of other questions to do, and I'll send you a lot of emails. That's the point, I would say. That's really amazing.
Okay.
Great.
Okay, well, the questions will be for the book. We can do another webinar when the book appears. Okay, then, if the participants want to say something or want to say goodbye.
Thank you so much, everyone. We are so grateful.
Okay.
Thank you very much. I'm so happy to have been able to participate, and for the organizer of this, and also the most interesting presentations and comments. Thank you very much.
I would like also to have to thank the opportunity to share with all of you, and I especially cherish the opportunity to start dialogue with the other works which have a lot in common with the research I'm doing. So I look forward to continue this dialogue. Have a nice day, and thank you very much.
Thank
Okay.
you very much.
Thank you.
Thank you very much.
Okay, thank you.
Thank you. Bye bye.
Sorry for the
See you on Saturday. See you on Saturday.
Good
See
luck.
you Sunday. Bye bye.
Thank you. Bye bye.
Bye.
Good luck.